What legal rights protect CFS patients working? Have you ever wondered what legal rights protect individuals with chronic fatigue syndrome, also known as myalgic encephalomyelitis, while they work? Patients with CFS are protected under several important laws in the United States that help ensure their rights in the workplace. These protections primarily come from the Americans with Disabilities Act, the Family and Medical Leave Act, and provisions for Social Security disability benefits. First, let's talk about the Americans with Disabilities Act. This law recognizes many chronic illnesses, including CFS as disabilities if they significantly limit one or more major life activities. Under this act, employers cannot discriminate against employees with disabilities. They are also required to provide reasonable accommodations to help these employees perform their jobs effectively. For someone with CFS, reasonable accommodations might include flexible work hours, modified job duties, periodic rest breaks, or even the option to work from home. Employers must engage in an interactive process with the employee to determine what accommodations are appropriate and do not impose undue hardship on the business. Next, we have the Family and Medical Leave Act. This law allows eligible employees to take unpaid, job-protected leave for serious health conditions, which can include CFS if it meets the criteria of a serious health condition. This leave can be taken intermittently or continuously, allowing individuals to manage their symptoms or attend medical appointments without the fear of losing their job. For those whose CFS symptoms are so severe that they cannot maintain employment, applying for Social Security disability benefits is an option. To qualify, individuals must provide medical evidence showing that their condition causes significant functional limitations, lasting or expected to last at least 12 months. It is important to note that symptoms alone do not establish disability. The documented effects on functioning are crucial in the evaluation process. CFS patients are also protected from discrimination in hiring, firing, promotions, and other employment terms. They cannot be retaliated against for requesting accommodations or for filing complaints related to disability discrimination. If a patient feels they have been discriminated against, they can start by filing a charge with the Equal Employment Opportunity Commission, which investigates and may mediate disputes before any legal action is taken. For practical application, it is essential for patients with CFS to document their medical conditions thoroughly and communicate openly with their employers about their needs. Utilizing resources like the U.S. Department of Labor's Job Accommodation Network can help facilitate discussions about possible accommodations. Examples of these accommodations include flexible scheduling, rest breaks, memory aids, and adjustments to workspaces to reduce sensory overload. In summary, individuals with CFS may have legal protections in the workplace that requiring employers to provide reasonable accommodations and protect against discrimination. They also have access to medical leave protections and disability benefits if their condition severely limits their ability to work. Understanding and asserting these rights can empower patients to manage their employment while navigating the challenges of CFS.